SJC-12130, Commonwealth versus Holley and another.
You may proceed. Ms. Billowitz.
Good morning. May it please the court, Elizabeth Billowitz for defendant appellant Reginald Holley. This is an appeal from a first-degree felony murder conviction. I'm first going to address the constitutionality of the search warrant as to my client, Mr. Holley's phone records. There are some factual distinctions between the two defendants. As time permits, I will then address the felony merger issue and the absence of a second-degree felony murder instruction, and those are issues that apply to both defendants. My co-counsel will then address probable cause specifically as to his client, as well as the remaining issues. The victim was shot to death in an apartment where he sold marijuana, and the security video showed two men who were never positively ID'd arriving at that time, with one of them speaking on a cell phone. They entered the building and exited a few minutes later. The last answered call to the victim's cell phone was at the same time as the call shown on the tape. This call was from a number that was linked to Mr. Holley. And with this information in hand, the police obtained a search warrant for 19 days worth of records associated with Mr. Holley's phone from the carrier, Metro PCS. They produced records including subscriber information, call details, cell site location information, and critically, the content of text messages. And the prosecutor introduced over a dozen incriminating text messages at trial that spanned a couple of days before the homicide.
To try to cut to the chase, can you address Commonwealth versus Fulgham and how that relates to the finding of probable cause? In your case, given that in Fulgham, there was a situation where the murders appeared to be the result of a drug robbery. Drug dealers tend to communicate via cell phone. On the day of the murder, Corbin's cell phone had multiple communications with messages with Fulgham and the victim. I mean, Fulgham seems to be on point with your defendant.
So the content of the affidavit here, and let me see if I can address this. It included the affidavit mentioned the surveillance videos, and that the last number was that the victim received was connected in time.
We have 1057 persons seen on a cell phone coming in. We know it's a drug ripoff. 11
That's
o'clock.
right.
11 o'clock. There's a shot, and the same two people are fleeing.
Well, I think the key point.
And your cell phone, your client's cell phone number is on the victim's cell.
That's right. But I think the key point that emerges from this court's recent decisions in Broom and White is that even when there is probable cause to suspect the defendant of being involved in a crime, that doesn't provide probable cause to search the content of text messages unless there's information, here's the key language, establishing the existence of particularized evidence likely to be found there. So the fact that he was making a call does not provide probable cause to search the content of text messages. And here, the particularized evidence...
So there was probable cause for the phone messages, but not text messages? Is that what you're saying?
That's correct. And below, the defendant's trial attorneys did not seek to suppress the call log information. Who made a call to who at what time. That's not the issue here. And that's a very distinct issue from the contents of cell messages, which is really like seeking the content of a cell phone conversation. And here it is one step removed because all that the affidavit says is that one of the males was seen making a call. He didn't say he was seen texting at that critical time. He was seen making a call. So there is a leap from the fact of a call to the content of text messages over the course of 19 days. And it's also important, as we focus on that particularized evidence that the Commonwealth has to show, what they say that the police were seeking was the caller's identity. And they say that the police didn't know who was making that call to the victim shortly before his death, and thought that the content of the text messages might somehow identify the culprit. This does not make sense on any level. First of all of the information you can get from a cell phone, the content of text messages is not where you're going to find identity.
Would there be probable cause to believe, in your view, that the call logs would relate to the crime?
I think that's right. And it's also important to note that at the time they sought the warrant, the police already knew that Mr. Holley was the person attached to this phone. They had that information from a BPD database.
Is there a legal doctrine that says the Commonwealth has to just get the evidence they have, they can't get more evidence? Isn't the standard just whether there's probable cause to get evidence?
I think
there's no good enough exception?
I think Broom indicates that the reviewing court can take into consideration what information was already available to the police at the time that they requested the warrant. And there, because the police already had the defendant's CSLI and phone records, the court said that they would have already known that the victim's cell number didn't appear in the records that were requested. And I think that same principle applies here. The police and the Commonwealth can't justify intruding into the content of text messages to get the caller's identity when they already knew that identity. And not only did they know it from the police database, but they requested and received the subscriber information, which had Mr. Holley's full and correct name on it. This was not a case.
Was there probable cause to believe that your client was a drug customer of the victim?
I would say that there could be probable cause for that. There could even if there is probable cause to believe that he's a drug customer, or even that he was a suspect in this homicide, it does not automatically follow that there is probable cause to obtain this type of private information. All text messages, all content. So to say that that one follows from the other, I think would really be contrary to this court's recent jurisprudence in White and in Broom and in Fulgium, which state that there is a more rigorous standard when we're talking about examining cell phone data. It has to be treated more rigorously than a search of a physical container. It has to be done with special care and satisfy a more narrow and demanding standard.
But this was not a search of a cell phone. This was a search of text messages that came from Metro PCS, correct?
That is correct.
So this is analogous to a transcripted log of conversations. I mean, in theory, there exists a transcripted log of short, misspelled conversations, and they're seeking that log effectively.
That's correct. And it's really, in this case of the text messages, it's the same data that was available both on the phone itself, for which there was a later warrant, as well as directly from the phone company.
Right, but I mean, I was going over the case law, the cases that we've recently decided. I mean, one case focuses on the limitation on the scope of what you can look at within a cell phone. The others focused on whether the opinion that there's something there is sufficient, which it's not, which focuses on particularized. But our standards in terms of what we've said are a little bit, we say particularized evidence is likely to be found on the device in question in White, and then in Fulgium, Dorellis. Such devices can still appropriately be searched where there is probable cause to believe they contain particularized evidence. and there was a substantial concluding that items sought are related to the criminal activity and that they reasonably may be expected to be located in the places. Communications can come as so long as such evidence, this is in Dorellis, may reasonably be found in the file. So the question is, how tough are we going to be in terms of what? I mean, it can't be that you necessarily say, I can look for texts only if I know that there is a text. Is that your position, that only if there's evidence that they were texting, can you look for texts?
I would say in this case, when there was no evidence that my client was texting, and the Commonwealth cannot point to anything that it was looking for in the text content other than the caller's identity.
Wouldn't they show a relationship between the defendant and the victim? Wouldn't that be highly probative?
Certainly, but again, the intrusion into text messages was that was an overbroad intrusion, and perhaps more to your question, Justice Gantz. I think that the standard as to intruding into data held by the third-party carrier, it's really the same universe
No, I agree with that.
of materials,
I don't
yes.
think it matters whether you look into his cell phone to look for texts or go to Metro PCS to look for texts. The issue is, I mean, really, when you clear out the debris with regard to your client, is it sufficient to say that there was probable cause to believe that he was involved in the shooting and that it was a drug ripoff from somebody who was purportedly buying drugs, and that there is some degree of likelihood that there would have been texts between them that would have set up a meeting which would confirm that indeed he was there to buy, which would be certainly relevant as to why they were there.
Well, I think this gets outside the four corners of the affidavit, because all that was mentioned in the affidavit were the surveillance videos, the fact that it was the last phone call. Again, no observations of him texting. There was no statement
But the
that
murder-
the two were communicating together via text.
But the affidavit's got, there's like 4-minute difference between, right, the phone call and and them leaving the building. So you have such a close connection to the phone call, the crime. It just seems different than some of these other cases where you're certainly going to find evidence on the phone confirming the crime, aren't you?
Well, I think it's problematic when we start eliding or merging different functions on a cell phone. There are calls, there are texts, there are photographs, there are many different mechanisms.
That's Dorellis, and the danger in Dorellis was when you give broad scope to search the cell phone, because you can get, as you say, photographs, et cetera. But isn't that gone when it's a warrant issued to Metro PCS? They're not going to give you photographs. They're not going to give you, you're not going to rummage through the cell phone when there's a directed search warrant that asks for these logs.
Well, here they were rummaging through text messages without any kind of...
No, but I'm talking about the other things. You mentioned photographs in the protected areas of a cell phone that we already talked about in Dorellis, about protected files that have nothing to do with an investigation. This is distinguishable from Dorellis because of that reason, correct?
Correct. My point was just that when we leap to, hey, we see this person using their cell phone for one purpose, let's get, under a probable cause standard, content based on other cell phone functions.
Is there any case law you found that narrows the scope of police authority in such a manner when there's probable cause to get cell phone calls that they can't get text messages?
I would simply point to this court's own recent standards saying that there needs to be particularized evidence likely to be found in the specific place searched, more specifically than cell phone records that would comprise both phone and text. And I would point out.
What about the fact that somebody takes the victim's phone too, which suggests that they're caught up in, eliminating the ability to review communications between the defendant and the victim, between the perpetrator and the victim, right? Does that suggest that there's even a heightened concern, and heightened likelihood that there's going to be reliable information there?
No, again.
Really? So why do they take the phone? Why does someone take the phone of the victim if they're not worried about eliminating traces of evidence?
I don't think that any inferences from the missing phone get you to particularized evidence being in the content of the text messages. To some on this point, yes, probable cause to believe the victim was murdered. Yes, probable cause to believe the owner of this phone number was involved. Probable cause to get the text messages was still only based on speculation that those 18 days of stored messages would provide evidence related to the murder.
So if they'd seen him texting as well as phoning, then that argument goes out the window. It's just they never saw him text?
If there was corresponding.
Because your co-defendant, they actually see him texting.
That's right, and I know that co-defendant's counsel will address that point. I would say that if the victim's phone records showed a corresponding text such that we knew that these text messages were relevant and directly connected, then absolutely.
I don't think
but
you'd
we
be
don't
here
have
if that.
that here.
I don't think you'd be arguing this if that was the case.
That's right. And I would also just say there could be a situation where a victim has recent multiple callers, and I would urge that we would be very careful about permitting the police to, under a probable cause standard, comb through the call log, text message, CSLI, and other data that reveal a wealth of highly private details about people's lives, just based on the fact that they were the last person called.
I'm afraid your time is up, so.
Thank you.
But we have your brief. Thank you so much.
Thank you.
Mr. Fishman, good morning.
May it please the court, Neil Fishman for the defendant Oasis Pritchett. Your Honors, my client is particularly well situated to take advantage of the warrant and suppression issue here. It is true that he was the one who was spotted in the affidavits. They seemed to be texting.
I'll ask you the same first question I asked co-counsel. Can you align this case with Fulgham?
I can align it perfectly, Your Honor. Fulgham, my reading of it is it just stands for the simple proposition that there is no third-party exception to the warrant requirement.
Right. But there's a PC discussion in Fulgham that deals with relationships between peoples and probable cause. Can you address that?
Yeah, so, Your Honor, just assuming, just for the purposes of this oral argument, assuming there's probable cause to believe that Pritchett was involved. I think my brief addresses that's questionable, but assuming there is, there wasn't probable cause to enter his cell phone. The mere fact that he seemed to be texting, of course, we all know that could mean that he's just checking hockey scores.
No, what I'm a little confused on, because the affidavits require some inferences. The affidavit says that he is seen on the bus or in the train station at the time after fleeing the homicide, but it doesn't give us any indication of when. Was it 10 minutes, 5 minutes, an hour?
I don't know, Your Honor. I think for the purpose of this argument, we can assume it was sometime after the homicide. The major
And I
point,
don't know if that matters, but frankly.
well, the major point is assuming for the sake of, he actually wasn't texting, but assuming for the sake of argument that he was texting, that's not enough to enter his cell phone to search for the text, because as it's plain and simple, he could have been texting about just about anything. Putting aside the probable cause issue, of course, is the very strong issues on particularity. Those issues have to do not only with the scope of the search, which the warrant called for, the all stored electronic and wire communications.
Would you concede that they had probable cause to get his call logs and/or the CSLI?
No, Your Honor, because my client is not in the same position as Holley. My client.
But if there's probable cause to believe he was a suspect, right? If we, and I know you dispute that, but assume for a second we find that we disagree and we find that there's probable cause to believe that he was a suspect based on these descriptions as association with Holley.
Right.
Would you then agree that, putting the text messages aside, that they had the authority, the lawful authority to get his CSLI and/or his call logs?
I would dispute that, Your Honor, for the reason that to go that far would be to say that cell phones are tools of joint ventures. And I know of no case law that says that.
But if he's carrying a cell phone in his pocket and we know it's on his person, isn't there probable cause to get his CSLI to see where he was, to see if he was at the victim's apartment?
Again, I think you're getting into the area that I think the officer found himself in with regard to the officer who made out the affidavit in support of the warrant. He said, I believe that because Oasis Pritchett was texting so soon after the homicide, he could very well be communicating about the incident.
No, this is different. I'm putting that aside. I'm asking you about the CSLI and the call logs.
I do understand, and I'd say the premises are the same. But frankly, it's the texts that are the most damaging for my client.
Well, they don't argue harmless error as well. The government does not argue harmless error with respect to the text messages.
That's right.
Nor could they.
Could you say that again?
Nor could they, right? With the text messages. So
I think they let that one go, and I think quite properly.
Could you remind me, does the affidavit reference that your client does not live with the co-defendant, that they don't work together, and that they join up? I can't remember if that's in the briefing or is that in the affidavit?
In the affidavit, there's a mention of some sort of association. I believe it's is it FI?
they FIO'd,
Yes.
and they
Right.
they were FIO'd together at some point in time.
At some point in time, according to the affidavit.
But I'm trying to see whether there's some reason to believe that they're going to have to communicate with each other by phone to meet up, that they don't live together. I just don't remember if that's in the affidavit too.
I don't recall seeing anything like that in the affidavit.
Because they see Holley phoning, they've got that connection. They see them arrive together. They see two people arrive together. I'm just wondering whether they've got a basis for believing they're communicating by phone based on where they live and other things. But that may not be in the affidavit.
And I do want to reiterate, Your Honor, that even if you find there was probable cause to believe that he was involved in the crime, I'm talking about Pritchett here, and probable cause to enter his phone, the way it was entered was completely abnegated the particularity requirement, both in terms of scope and span of the search. And the span, going back all the way to, I believe it was October 1st.
Scan should have been only for the day of the crime and only for what? Because text messages, because he's seen texting and not phone messages, the opposite of Holley?
You know, Your Honor, I don't think I could stand here and say what it should have been, but I could stand here and say that it was too broad, that to go back to the 1st of October was completely arbitrary, and to basically have a warrant for all stored contents of electronic or wire communication was overbroad. I have some very important other issues I do want to address to the court that really pertain to my client. I want to talk particularly about the prior bad act evidence. I think if you ask the average person on the street,
Before you get there,
sure.
are we limited to what the police officer said? That the key line, I guess his conclusion or his inference in the affidavit is, I believe since Pritchard was texting so soon after the homicide, he could very well be communicating about the incident.
That is a key line from the affidavit, yes, Your Honor.
Does that limit us as far as what we can believe the probable cause to be?
I think it does, Your Honor. I think it's speculation, and I think the officer tips his hand. At the end of the affidavit, he goes, this is in quotes, I believe that because, there is reasonable suspicion to believe that the information I seek under the authority of this order is material and irrelevant. Well, reasonable suspicion is not probable cause. I would argue there isn't even reasonable suspicion. I would argue it's speculation. I would argue the officer is operating under the premise that cell phones are tools of crime.
Let me make sure I understand what you're saying. If this were a case, which I know you say it's not, in which there was compelling probable cause, is it your position that when the affiant characterizes as reasonable suspicion, we're bound by that?
No, Your Honor, but I am saying it shows that I think that the affiant felt.
Okay, so you're saying it's illustrative here of the absence of probable cause.
It is, Your Honor.
But if he's in the other side of that coin, is if he said there was probable cause, then there's probable cause?
Well, that would be conclusory.
Okay, thanks. There's a heads I win, tails you lose deal?
It's a fair point, Your Honor.
All right.
But going to the prior bad act evidence here, I think if you ask the average person on the street that there was a murder trial, and in this murder trial, there was a trial within a trial about stolen guns. One of the stolen guns was indisputably not involved in the homicide. The other stolen gun was one of millions that could have been involved in this homicide. And they were talking about evidence of an uncharged crime, and the actual evidence that he was involved in the crime is tenuous, to put it lightly. I think the average person on the street would say that's not fair. And that is...
Are you talking about more prejudice than probative? Or you're saying that the judge didn't have grounds to believe that the 38 could have been the 38 credited in Camper's testimony?
I'm saying that the probative value of that evidence was outweighed. And of course, the test isn't that it has to be substantially outweighed, but it was substantially outweighed in this case by the potential for unfair prejudice. This was incredibly unfairly prejudicial evidence that was admitted to show. Basically, I call it in my brief, I call it thug evidence.
Even if the texts are admissible, which indicates that one of the reasons Pritchard's desirable is that he has guns. So if you lose on the text issue, are you still able to make that argument about the guns? Because isn't that why Holley's interested in him, is that he has weapons? I mean, I may have misinterpreted those texts, but I thought they say that he's got guns.
There's so many going back and forth. Now, at one point, my client says, I got a couple. In the context, it's hard to know, but viewing the evidence, in the light most favorable to the Commonwealth, that's an inference that he's saying, I have
So
guns.
you have to win the text case to win the gun point?
I disagree with that. It's
a question, not an answer. Yeah.
No, I think the gun evidence here was, by any measure, the potential for unfair prejudice outweighed its probative value. It had no probative value, none.
None? The Camper
one
said
gun-
that the guy was shot with a 38, he stole a 38.
One gun was excluded. The other was one of millions. And as I say in a footnote, the one that was one of millions, it didn't even appear in the ballistics experts' list of possible murder weapons. And moreover, according to the ATF records, it was not one of the stolen weapons. And we're not just talking about mere possession of stolen weapons. We're talking about, mere possession of weapons. We're talking about stolen weapons. We're talking about evidence of an uncharged crime. So I think if this isn't a case where the probative value was outweighed by the potential for unfair prejudice, I'm not sure what would be such a case.
I didn't go back to the text messages, but by the way, was there anybody who sought to interpret those text messages? I mean, they're in a heavy street slang.
I absolutely agree, Your Honor, and it was definitely an issue throughout the trial, but there was no expert witness or otherwise who interpreted the text messages.
And with regard to the timing of them, I'm trying to think back, the move of that person where the stolen guns allegedly occurred was a few days, how many days before the killing?
I'm unclear about that, Your Honor. It's in my papers somewhere, and it's in the Commonwealth's papers as well. But I'm not, the argument is not a temporality argument
Right,
that
but
I'm
I guess
making
my
here.
question is, with regard to the texts, I've not gone through them carefully to look to see whether there's any discussion of getting a gun. Is there any discussion about your client getting a gun or your client having just gotten a gun, which could bear on the relevance of the timing of it?
The only discussion that I recall from the texts, and again, texts are flying back and forth between these guys, is one where my client says, "I got a couple." And those aren't the exact words. I encourage the court to look for the exact words, which are in the brief. Before I run out of time, I did want to touch on the merger issue. The legal sufficiency part of that merger argument, I'd like to just let my papers speak for themselves on that, and just really go straight to the fact that my client asked for a jury instruction. My client asked that the court instruct the jury about merger.
Well, if we find that Christian controls, it doesn't matter. There's no jury instruction required, correct?
I don't see how Christian controls, Your Honor. I don't see how armed robbery, an element of armed robbery is assault. There's no proof here, absolutely none, that this was a putting in fear type of assault. The only type of assault that there is evidence of is a single gunshot wound to the head. If this isn't a case of merger, and I'm sorry to mime my own words from the prior bad acts stuff, I don't know what is. This was exactly the same assault. The homicide resulted from exactly the same assault that was an element of the armed robbery. If the court has any further questions, I would like to just reiterate that my client asked for a merger instruction and the court denied it. That's a preserved issue, so that's yet another reason to reverse this conviction.
One more question back to the texting, and I should know the answer to this, but I don't. So if the scope was too broad, if it was completely appropriate for the phones for 2 days or the day of the crime, but they asked for 18 days, what is the remedy for that? So if they had probable cause, and if they had asked for only a day, the day of the robbery and the murder, what happens when they've asked for 18 days?
The remedy is to reverse the conviction, particularly regarding to my client, because there were texts involved involving the stolen guns stuff. There was also a text after the homicide, well after it, to a woman, basically a confession, or something resembling a confession, I should say, that was used as evidence of a confession.
All right, thank you.
Thank you, Your Honor.
Ms. Campbell, good morning.
Good morning, and may it please the court, Kaylin Campbell on behalf of the Commonwealth. Before I start, I'd like to acknowledge the victim's family who is in court today. We ask you to affirm both defendants' convictions, and if the court has no objection, I'll start with the text message issues. And I think I'll start with some factual questions that were asked. Justice Gaziano, you asked if there was any information as to when Pritchett was seen looking like he was texting. In a paragraph, it says that they obtained MBTA surveillance video from just after the murder.
Right.
So I think it's a fair reading that this occurred just after the murder.
I got the just after. I was just wondering if it was more specific as to the time.
As to exactly when, no. The evidence at trial was more specific as to when.
I assume so, right? but
Yes,
not
and
here.
it was within 5 to 10 minutes of the murder.
All right, so we're stuck with just after.
Correct, just after. Justice Kafker, you asked a question as to whether there was information that the two individuals lived at different residences, and yes, there was in the Pritchett affidavit. In the Pritchett affidavit, they specifically speak of going to 90 Blue Hill Ave, which is where Mr. Pritchett resided, and they also went to a different address in Dorchester where they believed Mr. Holley resided. His mother was there. So I'd say from that, there was information to infer that they lived at different places. But what I will say is, first I'd like to acknowledge, too, that my brief was written without the benefit of the Fulgham case that came out after I wrote it. But I think that it is highly instructive and beneficial to the arguments that I make here today. As was conceded by both counsel, there was probable cause to believe a murder happened, and there was probable cause to believe that the two individuals depicted in the surveillance video were involved in that homicide. I don't think that it's necessarily dispositive that one of the individuals was seen placing a phone call rather than texting, as to the comments of text communications. And my reason for saying that is twofold. I would point back to the standard articulated in Fulgham, which provides that police can obtain the content of text messages if they prove one of two things. I believe that we have both here. The first is that the text messages will produce evidence of such offense, and the second is that it would aid in apprehension of a person who the applicant has probable cause to believe committed the offense. And what I think distinguishes this case from almost every single case that my brother and sister rely upon is that in this case, what you have is
Can I ask, before you do that 1 second, so were those, when you state that principle, were those cases in which the defendant was identified as texting? Because there's some division in our cases where we, allow phone stuff, but we don't allow texting, right?
Yes, yes. And I would say, in terms of the standard that I just articulated, no, because it's Fulgham, so I'd say that stands alone. The standard was just articulated, so there hasn't been, I think there's one appeals court case, Commonwealth v. Michael Jordan, that does discuss that. I would say that it's an unpublished appeals court case. I'd say that Jordan can be distinguished in that there was no evidence at all in the search warrant affidavit that even mentioned texting. There was no evidence of the phone being used around the time of the murder, so I'd say that is a distinguishing factor. But what you have here that you don't have in the cases relied upon by my brother and sister is that you have probable cause to believe a certain individual using a certain phone number committed a crime. What you don't know is the identity of that individual. And I disagree with my sister's characterization as to the Holley search warrant affidavit, because in the Holley search warrant affidavit, they say that a member of the Boston Police Special Investigations Unit did a limited search and was able to find the number that last called the victim. There's no information that they were able to find the identity of that person. That information gets expanded in the Pritchett affidavit, in which they say they're able to go through a police database and associate that number with Reginald Holley, but I'd say that shouldn't stop the police investigation. Just because an individual at one point in time gives a number as his own, that doesn't mean that he's still using that number at the time. It doesn't mean the number changed. It doesn't mean that the number's registered to someone else. And so I'd say that...
So you're arguing that the person, there was probable cause to believe that a person used a particular cell phone and committed a crime.
Correct.
And he used that cell phone to communicate with the victim, so therefore the means of communication via call or text or fair game.
Correct. And I'd say that I would point to the first Augustine opinion to say it recognizes the ubiquity of text messaging as a form of communication. And so I'd say you can't ignore that acknowledged ubiquity of text message communication.
That's kind of taken, well, not taken back, but that's kind of belied by White.
I would distinguish White in that in White, we knew first the identity of the person, and there was no information that the phones were used at all, either before or during or in the direct immediate aftermath of the murder.
How does all this help you with respect to Pritchett?
So I think...
Pritchett's a much more difficult case, would you say, Holley on the text messages?
No, I think Pritchett is a much stronger case, especially because you have the surveillance video just after the homicide. And I have moved to transmit these videos to the court so you can look at it yourself. But I think what you have is you have a Boston police detective looking at this video, seeing an individual. I think it's critical the quality of the video, because when you look at the video, you can match the two people that are seen in the MBTA videos to the two people that were in the lobby.
I don't think Justice Graziano was speaking about the probable cause to believe that they were involved in the crime.
Sure.
I think the issue is that second part as to if you have probable cause to believe that they're involved in the crime, what do you need then to get call logs, CSLI, or in this case, text messages, which is what was the most important evidence here.
Correct. I would say with call logs, you don't need probable cause to get call logs. You can get them via administrative subpoena, just to be clear that we're not conceding that you need probable
And CSLI focuses on location as opposed to communications, so I
Correct.
think we can put that aside. But so let's focus on the communications, which are private, which we don't.
Yes. And I'd say, like with the analysis with CSLI, so my answer is twofold. The first is that in this specific case, what you have is evidence that the police could point to that the phones were in use at particular times. So with Pritchett, looking at the surveillance video, there is sufficiently reliable evidence that you can look at that he appears to be texting. And I'd say that that is enough. That's a fact that you can point to, and I think it's important that it's in the just after the crime and the immediate aftermath of the crime. But in a case where you don't have that, in a case where you don't have a person on a surveillance video appearing to be texting, I think it's enough in an instance like this where there is a drug-related murder and cell phones and communicating specifically on cell phones is recognized in our law as an implement of drug dealing. I think that should be enough to get you communications.
Doesn't Fulgham say differently? In Fulgham, we said the application established a personal relationship between Thomas and Corbin. Corbin was in telephone contact with the victim and Fulgham on the day of the murders. The circumstances of the murder suggested a connection to drugs, but the fact that they used the cell phones to communicate with each other elevates it to a matter of importance, but doesn't justify intrusion into the communications.
And I'd say that simply flies in the face of existing precedent, the other existing precedent, which recognizes that.
And Fulgham was wrongly decided.
Correct. Correct. On that ground, absolutely.
And Fulgham is inconsistent with which one of our earlier decisions?
Sure. I cite a number of them in my brief, but I'd say Commonwealth v. Berry. And Commonwealth v. Berry, what you have, and the holding of Berry was overturned by the Supreme Court, but I think the holding as it applies to cell phones being an implement of the drug trade still stands. In Berry, what you have is an arrest of an individual who was seen prior to that engaged in a drug deal, a hand-to-hand drug deal, I believe, and the court in this court held that there was probable cause to seize that cell phone because there was a belief that it had been used for the drug deal and it was an implement of drug dealing generally.
So if we find that Fulgham was not wrongly decided, do you lose?
I don't believe so, because we have on the surveillance video Pritchett looking like he's texting. I think that should be sufficient. That's a sufficient fact that you can turn to in the...
Okay, if he's texting, does that mean that text message is inculpatory?
I don't think that the showing that I think there's a reasonable inference that it is. And I don't think my brother and my sister talk about innocent explanations, but when you're looking at the probable cause calculus, those innocent explanations don't negate the fair inference that it isn't an innocent text. I'd say it's entirely fair to believe that in the aftermath of a homicide, while you're fleeing the homicide, that you would be communicating about that homicide, especially where there's information that before the homicide, your joint venture was using his phone to set up the homicide.
I'm not sure I entirely understand. Are you saying that the fact that he texted is important because it shows that he used texts to communicate, and therefore one can infer that there are other texts that matter, or are you suggesting that we need to focus on that particular text, that there's something that we can expect to be potentially incriminating from that text?
I think both. I think both could be true, but I think that more important to the analysis is that in the immediate aftermath of the homicide, he is seen texting.
Okay, I mean, if we,
Just as-
if it turned out that you had learned, which I have no idea what that text ultimately turned out to be, but imagine a situation in which you learned from a girlfriend that, yeah, he texted me shortly after the alleged event and said, "What's for dinner?" Would the fact that that was an innocent text bear on the issue of probable cause, or are you really focusing on the fact that here's a guy who texts, and a guy who texts and is involved in a drug ripoff is likely to have communications that are relevant to that?
At what point in time would the affiant learn that he had just texted his girlfriend?
I'm sorry, at what point in time would?
Did the affiant learn that he had texted his girlfriend?
I'm saying that imagine a situation in which you were able to identify the particular text, and it was
Before?
clearly innocent. It was after. I mean, you learn that text turns out not to matter.
I would say that has absolutely no bearing on the analysis at all. We don't judge the reasonableness of a search based on what that search turns out.
Well, of course, I understand that, but
And
I mean,
so
okay, but then again, we don't know. I mean, if you're focusing on that particular text, we have no clue what that particular text
And I'd say,
was.
I guess I would offer an analogy. If you see an individual run directly into a home after they commit a crime, it could be entirely possible that they don't have any evidence related to the crime on them anymore. And so when you search the house, you won't find anything. I think here what you have is a similar situation in which you see the defendant take an action where it's possible that it could have incriminating.
When you ask us to draw these inferences based on the fact that he used text messages to communicate, albeit right after he committed the crime, allegedly, aren't you really arguing what we rejected in White, that the government can't rely on the ubiquitous nature of cell phones to carry the day?
No, not at all. Because in White, you don't even have.
I realize in White there was no, right, but we also said that the fact that people carry cell phones every day and they're so common isn't enough, absent particularized information, that you're using not only a cell phone, but a cell phone to commit the crime, associated with the crime.
And I would say, no, that wasn't rejected in White. And I would also say, to look at this, I think the problem is when oftentimes these cell phone issues are considered, they're not considered in a practical way, and they're not considered like we consider any other piece of evidence in any other crime. So let's say we have a homicide and it's a shooting homicide, and you stop well, let's say you have a homicide and you find an individual that just has a wound that's a bunch of blood. I've lost my train of thought, so I'll stop that example, but
I get what you're saying, that we should remember its probable cause and not be hyper-technical.
Correct.
I get that, but we also are saying these are protected communications, and the government still has to show particularized information to intrude upon protected communications.
And I believe here we absolutely have, specifically where we can point to, in Holley's case, the phone call before, the fact that it's a drug-related homicide, in Pritchett's case, the fact that he's seen to be texting in the immediate aftermath of a crime.
I'm confused, though, how we square Holley with, how we allow the Holley search consistent with Fulgham. Just articulate that for me, or do we have to reverse what we just did in Fulgham to get there? Because I found it tricky after reading Fulgham.
Correct, and I would agree with you there. But I would say in terms of Holley, insofar as you don't find that there's probable cause for his text messages, I would jump to my harmless beyond a reasonable doubt argument, because you get Holley's text messages through Pritchett's text messages.
And you don't make that, nor could you in Pritchett.
No.
So,
Pritchett rises and falls
so
on
Holley
on
is
his
harmless
affidavit.
because we have the right to Pritchett's.
Correct. But again, I want to turn back to the standard of probable cause, because we are asking, and a lot of times what you're asking the police to do is to say, I know for certain that a text message was sent, and here's the content of the text message. And that's never been required anywhere in the jurisprudence that I could find related to probable cause. It's just that there's sufficiently reliable facts that you could turn to that would lead a person of, I think it's a reasonably prudent man of caution, to believe that there would be evidence related to the offense. And I think looking at what's articulated in the affidavits here, we have that. It's not an instance where there's not this type of information. And I think that's what Onyx White is. I think Onyx White, we were entirely relying upon the ubiquity of cell phones and the fact that they're two joint venturers working together. We didn't have the same type of information that we'd have here. But I'd also draw the distinction that this is an entirely different search, and this will lead me to the particularity argument, in that the police, I don't think that this is an instance like Dorless where the heightened standard of particularity should apply, because this isn't the same type of forensic search. I understand what the case law is as to a forensic search of an actual digital device, but this search isn't that. And to put the police in a situation in which they're required to...
I have a little trouble following that, because doesn't the telephone company have the exact, when they have this information, don't they have everything on your phone? Maybe they don't, but I just don't understand. So what do they, okay. I was actually surprised to learn they have all the texts. What else do they, what don't they have?
So I'll explain. In terms of the content of text messages, it's very few service providers that actually keep the content of text messages. In this instance, it was Metro PCS. Metro PCS has subsequently been bought by a different, I think it's T-Mobile, and they're no longer keeping the content of text messages. So how applicable this rule is going forward as to content of text messages, I'm not sure. Because
right, but just in this context, what didn't they have that would be on
a digital device?
Yeah.
So I'd say on your actual cell phone, you have photographs, which in my experience, cell phone companies don't have. You have your calendar, you have any sort of notes that you keep in there, you have any kind of application that's in your cell phone. The cell phone companies don't have any of this.
They have all the communications you're having with everyone, at least on text.
At least on text. Mm-hmm. Correct, although I'm not sure to the extent that there's a difference between SMS text messages and a sort of cloud-based Apple-to-Apple text messaging. I'm not...
What I understand, possibly the Apple-to-Apple would be coded or protected.
Correct.
But when they're communicating with a different phone, which they're doing here, with a different phone company, then it's open text.
This was also 2012, so I'm not sure the actual type of cell phones, whether they were smartphones or not smartphones that were being used. But I say the qualitative, what you get from the phone company largely, and you can look at the record appendix as a representative example, it's mostly a spreadsheet. So it's not the same sort of type and vast amount of information that you would get from a forensic search of a cell phone. I would also say forensic search of a cell phone, you can see that files have been deleted or not deleted, which lends itself to an inference of consciousness of guilt that you wouldn't get from.
Can I go back to another point? You're saying that this is all going to be saved because Pritchett's is okay. Pritchett's, again, the affidavit's not fresh in my head. Pritchett's mentions the Holley phone call?
No, it doesn't. Pritchett does mention that, yeah, it does mention the Holley phone call.
Because that's the critical fact, right, is that Holley has called the victim 3 minutes before the victim's killed or something to that effect. So that's in the Pritchett. All of the good stuff for you in the Holley affidavit is in the Pritchett affidavit?
Yes, almost every single thing that's in the Holley affidavit is in the Pritchett affidavit, just expanded upon, because the Holley affidavit was filed 4 days after the murder on October 22nd, and the Pritchett affidavit was filed on November 8th. So it just details how much more of an investigation had taken place by the time that they applied for the Pritchett affidavit.
So what do you say the standard should be? Where there is probable cause to believe the individual is involved in the crime, you may seek text messages where
Where there is sufficient reliable information that would support that text messaging was used related to the crime.
In this affidavit, the police officer says, because I'm focusing on Pritchett, because Pritchett was texting soon after the homicide, they very well could be communicating about the incident. Are we limited to that theory, or can we be more expansive, as you just suggested?
You can be more expensive, I'd say, because the officer's subjective intent doesn't control. I would also like to point out that this affidavit was authored in November of 2012, so it was authored without the benefit of any of the case law that came
Right, which is going to be the case in a lot of.
Correct.
This is a fast-moving.
Correct.
In homicide cases, naturally take some time to try and for appeal. So you're not alone in appellate cases trying to catch up with evolving technology and evolving law.
I understand that. I'd say it
But
more.
we're still looking at the PC standard no matter what.
We are still looking at the PC standard. I say to the extent that it could have been better written, an affidavit that was written today for the search of a cell phone would look very different than this affidavit. But I don't think that negates.
Which doesn't help you, but I understand.
Yes, I think it's worth repeating, as it often gets lost in the jurisprudence.
Your brother argues that the scope it's 18 days, and that's way too long, and that in and of itself makes the application problematic. What's your response to that?
I disagree with that because of the nature of the crime, and I'd say that when you have a drug deal has to be set up, and it is reasonable to infer that there would be communications related to the drug deal. But I'd also say that it's reasonable to infer where you have a joint venture crime and you know that these individuals are using their cell phones in furtherance of their crime, that there could be information that shows their relationship to the victim. There could be information that shows their relationship to each other.
Does the affidavit mention, I know that the victim's wife said that he doesn't let people into the apartment unless he knows them, right? Or he doesn't
Correct.
sell to people there unless he knows them. That's in the affidavit
It
too?
is. It is in the affidavit.
How valuable is that in terms of getting to the text?
I think it is valuable. I think the fact that they were let in supports an inference that the victim knew at least one of these individuals. I'd also like to point out that I do think that the fact that you pointed out during my brother's argument that the victim's iPhone had been stolen, I think that is also a critical fact that the court can consider, in that it supports the inference that there was something on that cell phone that needed to be taken away.
That's more relevant for Holley, not Pritchard, though, right?
I think it's relevant for both of them. I think there's a fair inference that they both were together, committed this crime together.
But there's no evidence that Pritchett was in communication with the victim.
There's not, but there's probable cause to believe that he was involved in the homicide. So to the extent that there was a belief that there was information on the phone, I think that belief would be imputed onto him just the same as it would with Holley.
How old are these gentlemen? The two defendants are how old, roughly? Is that in the record anywhere?
I'm not sure if it's in the record anywhere.
But
They're not older. It's not as if they're 50 years old.
Yeah, no, I know we're not allowed to look into societal issues anymore, but if they're teenagers or 20-year-olds, they tend to communicate by text, not by phone, but I guess that's irrelevant. We don't have any evidence to support that, right?
We don't, and I apologize. It may be, their dates of birth may be in the affidavit. I just don't know that information off the top of my head. But I would turn to the firearm issue that my brother brought up with Pritchett. And I would say that, someone, and I apologize, asked the question as to when it happened in relation to the homicide. It was 5 days before. But my brother harped on that the average person on the street wouldn't think that this is fair, and that's not the standard that the court has to apply. It's whether Judge Brady abused his discretion in allowing this evidence to come in, and he didn't. It's what you have is an instance in which there are text messages on the murder, the morning of the murder, to Holley, from Holley to Pritchett, asking if he had access to firearms, essentially. He said, "You have a hand joint." Pritchett responds, "Yes, a couple." And I think that's where the evidence that he stole not only a firearm that could be the murder weapon, but also another firearm.
Hand joint that's code for firearms? I thought it was some other, you got stick or something like that? I couldn't remember.
So the stick, that's before the homicide. The two defendants are texting back and forth, "Hey, you want to do a stick?" There was evidence that meant hold up, a stick up.
Right.
I believe that there is testimony that hand joint, a joint is a slang for a firearm, hand joint
That's in the record somewhere?
I believe so, yes. But I think it's important that his response is, I have a couple. There's then text messages in which they talk about how they want a revolver so they can cock it back so the victim can hear it. And I think it's critical that one of the firearms that was stolen from the Charlestown property was a small revolver. So it goes in completely with this plan. The fact that he had access to these firearms is part and parcel of the plan to rob and murder, or to rob, which
Some
resulted.
discussion of the victim has sawed off, right?
No, I don't believe.
Okay, maybe I'm confusing it differently.
Yeah, I don't think that there's a discussion that the victim had a sawed off. And that's where I disagree with my sister's reply brief, in which she talks about the possession of firearm being a prerequisite felony for second-degree murder. I don't think in this record there's any evidence that either defendant knew that the victim was known to have a firearm to protect himself when he dealt marijuana. And so I'd say that lack of knowledge distinguishes it from both Garner and Ortiz, which both defendants rely upon to make their argument. I'd say here there's simply, we had a firearm. There's nothing to show that they possessed that firearm in any way that.
What is this, got a couple rifles sawed off, no hand joints, you had a hand joint? I got I can get my hands on a joint, but then shits is too big, got a couple rifles sawed off, no hand, what's that all about?
Can you,
I'm reading from your brief, page 6, I think.
can you say the page number again? I'm sorry.
I'm reading from your brief on page 6.
Sure. That's before the murder?
So that's not talking about the victim.
No, that's not talking about a victim. That's talking about the firearms that they have access to that they could use to rob the victim.
Okay.
Okay, thank you.
Thank you.